My name is Clifton Johnson. I'm the founder of the Empower Series Incorporated, which is a 501c3 nonprofit organization brought to you by the generous donations of Comerica Bank, AE Media Group, and you. So thank you. October is National Estate Planning Awareness Month. And to help increase the awareness of the importance of estate planning, our guest today is Jennifer Lewis. Jennifer is an attorney and a partner at Farrow-Gillespie, Heath, Witter. She's board certified in estate planning and probate law. Jennifer, welcome to the Empower Series.
Thank you for having me.
Jennifer, it's been a while since we've talked. We met each other back in 2009, I believe, when I was a financial advisor in the same building that your practice is in. And you helped me and a number of my clients really get their estate planning together. So thank you for that. I know I thanked you during that time, but I'm going to thank you now. And also thank you again for sharing your wisdom with the Empower Series community here.
It's my pleasure.
Cool, cool. Now, I think back when we met initially, there's been some changes. So definitely COVID-19 has happened, and but you're still servicing your clients. I see you're working from home now, right?
Yes, yes. Welcome to my home.
Okay, okay. And you're a partner?
So I am, yes. I made partner. Thank you. I made partner in 2016.
All right. And you also are board certified now.
Yes, that's correct as well. I'm board certified, which basically means I took a test that's specifically about estate planning and probate, and my practice is primarily that area.
Right. And I hear only 10% of the licensed attorneys in Texas are actually board certified. So again, congratulations for that. And we're going to now talk about the basics of estate planning. A lot of people hear that term, but I hear around 70% of Americans are don't have adequate estate planning documents in place. Did you hear the same figure?
Yeah, I believe that's correct. Our goal, my mission, as it were, is to change that in Texas at least, right? And so that's why I do these sort of things, and that's why I'm passionate about being an estate planning attorney, because estate planning really is for everyone. It's not just for the ultra high net worth individual. Most people, in fact, almost everybody needs estate planning.
Yeah, yeah, I know that's important. So like you said, if you're 18, you're now an adult, and to sit down and really think about, okay, what's going to happen? It's not a nice thing to think about, I guess. Like at some point, I'm not going to wake up tomorrow, but what really happens is that there's a lot of family members and people that you care for and who love you who are going to be impacted by you not being here. And so really estate planning is really for them. It's for your loved ones and your family and the people who are definitely going to be impacted if you're not around. And like you said, it's not just for the people who are wealthy, it's for everyone. So thank you again.
That's right.
I can't wait to dive into this estate planning one-on-one with you. The way this is going to work, I'm going to ask you some basic questions and you just kind of dive in with your answers and give us the information that you feel is fundamental for everybody to know. So let's just first talk about what is estate planning?
Yeah, so estate planning is basically, there's a lot of documents that make up estate planning documents, and I'll kind of go through each of them briefly. So everyone kind of has heard of a will. Most people understand what a will is. So a will is a piece of paper that once you die, it takes your property and it gives it to whoever you're giving it to. You can give things to your spouse, to your children, to your friends. So whoever you choose to give things to, you use the will as the vehicle that actually makes that gift. And it is only effective after you die. So until you die, you can change it as many times as you want to. So each will that you make replaces your previous will. And so you can have multiple wills, but obviously only the last one in time would control. And then once you die, that becomes your actual will that is admitted to probate and used to transfer your assets. And so when people hear estate planning, they mainly think of a will, but there's actually a lot of other documents that they would need as well. The next one I would want to talk about with you is called a statutory durable power of attorney. And it's basically a financial document that says you can either make it effective immediately or upon your disability. So it says either right now or in the future when I become disabled, I want this person to be able to handle my finances. And so you pick an agent and that person can control your finances in the event of your disability or immediately if you so choose. And so that's called the statutory durable power of attorney. They're very important as well. You mentioned minors when you turn 18. So when you turn 18, your parents no longer have access to your doctors. They no longer have access to your bank accounts, right? Because you are of age. So once you turn 18, having a statutory power of attorney becomes helpful in the event that you're incapacitated. Someone can take over your finances for you. The other document, the next document that I'm going to talk about that an 18-year-old should also consider having is called a medical power of attorney. And it does the similar thing, except it's just medical decisions. So in the event that you cannot make medical decisions for yourself, it states the order in which you want people to make them for you. And so if you're in a car accident or, a coma, something like that, it lets people make medical decisions for you when you are unable to do so for yourself.
So a lot of times people say, there's some questions around whether you need an attorney to create these documents or not. You have all these different services online. Was it LegalZoom.com? You've got, you can Google will or power of attorney, medical power of attorney, and download all of these different templates about filling out those documents. What is your recommendation when it comes to completing these documents, the importance of using an attorney versus just doing it yourself?
Yeah, so I like to tell people basically what you pay for is my brain, is knowing which questions to ask and what order to ask them to make sure that I put on paper exactly what you want. A lot of times people don't think through all of the eventual potential outcomes. And I find myself, this is what I do all day, every day, right? And so I find myself asking people questions that they say, you know what, I'd never even thought of that. And so I think a lot of what the value add of coming to attorney is for us to know, honestly, to know the questions to ask you so that you can tell me what you want and so that I can put that down on paper and make sure your document's exactly what you want. There's also a lot of formalities that are required for a will to sign them. And so I'm not familiar, I don't look at the LegalZoom wills, right? So I don't know exactly how detailed their instructions are signing, but you have to sign a will in the presence of 2 witnesses over the age of 14. And in order for those 2 witnesses not to have to go to court with you, you have to sign an affidavit called a self-proving affidavit. And so there's a couple different things that you need to do to make sure your will is valid. And so hopefully that LegalZoom provides you detailed enough instructions about that. But obviously, if you did a will with me or most other attorneys, they will be there when you sign it, so that if anybody ever contested it, they would be the ones that went before a judge to prove up the will was valid. And so there's a lot of value add that I think going to an attorney has over doing documents online.
Yeah, I guess there's a range of how much you would pay for the services of an attorney. I guess on the low end, what have you seen out there that attorneys normally charge for a basic, simple will? And these are not your rates, but what have you seen from a range of what attorneys have charged?
I mean, I try to check the market from time to time to make sure our prices are competitive. We offer, just so you know, our firm offers a package. So I don't give anyone just a will because there's no way of me knowing what you're going to need, which document you're going to need. And so I like to offer a package. So, you know, you get this exact set of documents, all of them for this set price. But I'm not sure. I don't even know what LegalZoom offers. I would say some people would certainly probably do a will for maybe, you could probably find an attorney that would do one for $500 would be my guess. But most attorneys are going to charge you around $1,000 for a package of estate planning documents. Most attorneys in Texas, at least. Yeah.
And then if your situation is more complex, like you need a trust and other documents, it may be more, but anywhere from like $500 on the lowest to over $1,000. And also, if you're thinking, or someone is thinking, well, that's a lot of money, I don't know if I want to pay that much, then you got to go into what is the value of your estate? Because there might be some estates out there that are not really valued high enough to go through the probate process. And we had talked about that a little bit before. Is there a certain value range that you say makes sense for someone to go through the probate process?
So really quickly, before we get through that, because I think this will help understand. So there are probate assets and non-probate assets. So at your death, non-probate assets are anything that transfers with a payable and death beneficiary. So life insurance, any bank account that has a payable and death beneficiary, 401ks, 403bs, IRAs, anything, even brokerage accounts, anything that you can name a beneficiary of. If you name a beneficiary and that beneficiary is not my estate, that's a non-probate asset. So that means even if you have a will, those assets don't go according to your will, they go to whoever you designated. So if you start thinking through your assets and you think, okay, I've got a bank account, I have a payable on death beneficiary. I've got life insurance, I have a payable on death beneficiary. Brokerage account, IRA, payable on death beneficiary. Really the only other assets I have are a house and a car. We can use different things to transfer those house and those cars without going through probate. So specifically with regard to your house and your car, there's something called an affidavit of heirship that you can file after your death. Well, not you, whoever is taking care of your estate would file after your death, and it would give your asset to whoever your statutory beneficiary is. So let me back up. The code, there is a Texas Estates Code dictates who would take your assets if you die without a will. And so when I say the statutory code, basically if you die with a spouse and with children from your spouse would take. If you die with a spouse and with children from a previous relationship, then your children would take. So that's what the statutory code says, just as a very high level. I mean, obviously it's more complex than that. There's things about without children, without spouses, you know, so, but the statute will say who takes if you die without a will. There's something new, relatively new. A couple years ago, the legislature came out with something called a transfer on death deed. And so that is an actual deed that you can file before you die, just in the real property records, that says, at my death, I want my house to go to so-and-so. And so a Todd goes outside of the statutory code, right? You can give it to whoever you want. You just say, at my death, I want my house to go to so-and-so. And if you fill out one of those, you can avoid probate by having the Todd to transfer your house, assuming that the only asset that you needed to transfer was your house. Because like I said, you made all those other accounts non-probate accounts by designating a beneficiary. So there's some other things that you can do. Those are just a couple examples of ways you can avoid probate while still not having an estate plan.
Okay, so just to get this straight, if your estate or the person's estate is non-liquid, meaning that you don't have a significant amount of assets or accounts that are going to your estate, you've identified beneficiaries as individuals or entities or charities and not your estate for your bank accounts, your savings account, your retirement accounts, your life insurance. That's outside of your estate and outside of probate. And then if you only have a house, then there's this TODD form that can actually transfer the deed to whoever you want it to go to and avoid probate. And then if you have a car, there's an affidavit of heirship that the DMV has that allows a person to transfer the title of the car to the heirs. And that is the least expensive way of settling an estate that doesn't have a lot of, like you said, a lot of assets, land or property or homes and things of that nature. But in most cases, people think their estate is simpler than it really is.
That's right.
And so once someone has identified what they would like to have happen, it is very valuable to sit down with an attorney and talk this through. And like you said, you get what you pay for. To really make sure that at the end of that conversation, you are aware of what legal documents are required so that upon your passing, your family is not left with a mess, which is what most people who don't do the estate planning process is left with, right?
That's right.
Okay. And so there's a number of documents. We'll go into them in a little bit more detail, but then there's also this thing called a small estate affidavit. Mm-hmm. What is that?
So a small estate affidavit is, I guess it's kind of similar to that affidavit of heirship that we talked about that gets filed in the real property records, but a small estate affidavit actually gets filed in the probate court instead. And it says that you didn't have a will and your estate is less than $50,000 and your estate should go to these individuals. And then it lists, based on the statutory code, like I mentioned before, who your heirs are. And so it's a step up basically from that affidavit of heirship because it's filed in the real property records, but it basically is just another way to transfer property if you die without a will.
But still in the planning process, in order to fill out that document, someone has to go through and accurately assess the value of that estate and the property in that estate and do an inventory of all of the accounts, debts, and everything else. Is that correct? Right.
During a probate, yes.
So even though it reduces some costs and it streamlines some things, it still takes some planning to really make sure that the people who are left behind know your estate well enough so they can complete that affidavit properly.
Right. Right.
Okay.
If you have a will or not, I highly recommend every individual has just a summary sheet of their assets that are somewhere and give it to someone that you trust, a family member, a friend, anybody that you trust. A perfect example is life insurance. If you don't know who the individual had life insurance through, it's going to be a heartache, a nightmare for whoever has to go and try to find your life insurance policy, because they're literally going to have to call every single company. If they can't access your bank account to figure out who you paid your premiums to, they're going to call every single life insurance company. And there are hundreds of them because there's not a database out there for information like that. So things like that, just kind of a summary sheet. My bank account is with Chase. My life insurance is with Northwestern Mutual. Things like that will make your life so much easier for whoever is trying to handle your estate. Whether you have a will or not, having a list of assets is really helpful. And you don't have to have values on it if you don't want whoever you're giving it to know the values, but at least these are my banks. You know, I have these 2 banks, or I have this 1 bank, just so that they know where they need to reach out to if something happens to you.
Okay, so that's great, because you got to be organized. So let's just say someone's coming in to meet with you for the first time. What type of prep work do you have them go through in that initial meeting with you, or before the initial meeting?
Yeah, so I send everybody who reaches out to me for estate planning, I send them a trusted persons and last wishes document that they can fill out, kind of like a questionnaire, to start thinking about, okay, who would I want to make financial decisions for me if I wasn't able to? Who would I want to make medical decisions for me if I wasn't able to? And then it just lists high level their assets, so that when we're talking through in the meeting, we can talk through what they want where they want their assets to go. A lot of people want everything to go to their spouse. That's pretty easy to plan for, but some people have separate assets that they want to go to other individuals. For example, I want my car to go to my nephew, things like that. So if they have a list of their assets, we can kind of go through them, and any special gifts that they want to make, we can talk through. And then I always ask them to give me that list of assets. I ask them to give that to me as well, so that if they didn't want to give it to, you know, their father, their son, their whoever is going to be their executor, if they didn't want to give that list to them, I have it. And then if something happens to them and they can provide me with a death certificate, I will give that list of assets to their next of kin, whoever's going to be their executor. So if they have privacy concerns, I can be kind of the gatekeeper of all of that documentation, all of those files, until we need to give them to the person who's actually going to be using them. So.
Okay, so the first step is to really just organize, and like you said, identify the responsible people in your life that you would want to be the executor, who's going to handle all of your affairs upon your passing. Someone who, even before you pass away, if you're not able to handle your financial decisions because of, you know, you have a stroke or you're just incapacitated, you know, who is responsible enough to handle your financial affairs? Then who can make medical decisions if you're not able to make your medical decisions? And so some of the challenges that people, if they don't have somebody within their circle to pick, how do you help them pick somebody if they say they don't know anyone?
Yeah, so there are services that are willing to serve as your executor or your trustee. There's corporate trustees. So like banks, a lot of times their trust office is willing to serve. I normally don't recommend that unless you have significant assets, because it's expensive compared to just a person you know. So most people, when we talk through it and we really get down to it, they at least have a friend that they would trust enough. They may not have family that's close by, but they have a friend or a couple different friends that they can use. A lot of times people use different people for their financial decisions than their medical. Maybe their sister's a nurse, but she's awful with money. Well, she'd be a great person to be your medical power of attorney, and maybe her husband, right, your brother-in-law may be good with money, but you wouldn't want him to make medical decisions. But the beauty of these documents is you can have different people. So the sister who's good at medical decisions can be your medical power of attorney. The brother-in-law who's good with financial decisions can be your financial power of attorney. And you can kind of piecemeal together from all of the people you know, a list of people that can help you in the event you need to. And then worst case scenario, I've had it happen before. If you really know no one, we can always name a corporate or a professional person to serve in those roles.
Yeah, and like you said, if your estate is not valued at a certain amount, it may not be productive. And I don't know if it was you and I who came up with this, but one exercise is just to go through your contact list on your phone, because there might be somebody in there that doesn't come to mind immediately. But as you go through your contacts, it might be, oh yeah, I remember this person, and this person is really responsible. But I know those are some tough decisions sometimes for some people. And it's not always in the first meeting, you may not have the answers to all of the questions in your questionnaire, but it's important to put some thought to it and then come into that meeting having at least put some thought to it, right?
Right.
And then they can ask some clarifying questions with you and then get some additional guidance.
That's right.
So step us through the process. So someone comes in, they get the questionnaire, they do as much as they can, and then what would you say the next process is if they're meeting with you and they got to go through this estate planning process, they don't know what it is, but you're guiding them through it. What's the next step?
Right. Yep. So the first meeting that we have is where I generally explain each of the documents. So kind of like we've done today, I go over the documents in some degree of detail and then have them tell me who they would want to be their agent for each of the documents. And then I'm here to brainstorm with them, right? So they may have minor children. They may want to create a trust for their children. We talk through at what age would you want the trust to terminate, the child to get the money outright. Who do you trust to be the trustee? So all of these appointments that they have to come up with, the first couple meetings are us determining who those individuals will be that they will use as their agents. And then once I get all those questions answered, I actually draft the documents and I send them to all of the clients as a draft prior to us scheduling a review of them so that they can read through them, try to understand them to some degree. And then the most important next step, which is obviously important for them, is that they and I sit down. It's been over Zoom since COVID, and I actually really like reviewing the documents over Zoom. I think it's something I'm going to continue to implement even after COVID, because I pull up my screen and show them their document on my share screen, and then I can highlight the sections I want them to read. And so they sitting there on Zoom can read through it, and it just makes life a lot easier. I used to do that with them in person in the signing conference, but now we do it beforehand. And I like it too, because if they have any changes, let's say I misspelled an address, I can make those changes as we're reviewing the documents and answer any of their questions. We talk through what each of the document means, any questions they may have about the documents, any potential changes they may want to make during that Zoom conference, and get them comfortable with each of the documents. And once they feel comfortable, that's when we schedule a signing conference and we actually sign all the documents. So that's kind of the process. It takes anywhere from a week to a month to 2 months, depending on how long you take to get back to me to do all of that. And then once they leave the signing conference, they have all their documents and they're good to go.
Okay, so let's talk about the planning process, because a lot of people think that the will is it. It may be the cornerstone, but that's not really the estate planning process is stuff that can happen before you pass away. So there's a living will, there's a revocable trust, an irrevocable trust, power of attorney. Kind of explain the planning process and the opportunity to do the planning before something happens.
So the reason estate planning is so important is because you only can plan from now until whenever you have some sort of mental incapacity happen. And obviously we don't have a crystal ball to know when you're going to get in a car accident, have a coma, right? But the documents that you use to plan, they encompass anything that could possibly happen to you. So once you have them, you are set. Even if you become incapacitated later, you are good to go. So basically your planning period is from now until anything happens to you to make you incapacitated. But the documents themselves, they run longer than that period of time. So the reason the medical power of attorney and the durable power of attorney are so powerful and so helpful is because you use them once you're incapacitated, right? Whoever is your agent uses them once you're incapacitated to make decisions for you, but you can only create them now while you're healthy. And so people come into my office all the time, I mean, at least once a month, saying, hey, mom or dad isn't doing well. I need to make decisions for them. And I say, well, do you have a power of attorney? They say no. And I say, let's talk through their capacity. How are they doing? And the person says, well, they have dementia. They can no longer make decisions for themselves. At that point, the damage is done. The only thing that you can do is a guardianship. You have to actually go to court and get a guardianship for that person in order to make financial and medical decisions for them. Whereas if they had just come in a little bit earlier when the person, prior to the dementia getting bad, before the person was incapacitated, we could have done a really quick medical power of attorney and a durable power of attorney so that you could be making those decisions without court involvement now, right? So unfortunately, you can't wait until it's too late. You have to plan prior to the mental illness, prior to any sort of diagnosis that deems them to be incompetent, because guardianships are expensive. Attorneys have to be involved. There's no way to do a guardianship without an attorney, and so that just makes them expensive. Whereas medical power of attorneys and durable power of attorneys, other than preparing them, you never have to talk to an attorney. So plan now. Even if, you know, if you get, the second you get a bad diagnosis, you're worried about your mental capacity declining in the next 5 to 10 years, plan today. Plan today while you still have capacity so that everything is in place. Once the mental incapacity happens or the catastrophic illness happens, you have all the documents you need.
So those are two critical documents. The durable power of attorney and the medical power of attorney are needed now while you're alive. And if you make the decision as to who will be your agent to get those documents done while you're in good, while you have the right, when you're in the right frame of mind, that's the best way of getting those documents done. One of the documents that's kind of confusing with the medical power of attorney is the living will. So what's the difference between the living will and the medical power of attorney?
Yeah, a lot of people think they're the same document. So a medical power of attorney, we already talked about it, but really quick, I'll tell you again, is the document that says, this is who I want to make medical decisions for me if I'm unable to make them for myself. So your medical power of attorney is a person who makes decisions for you if you can't do so. The living will, it's also known as advance directive to physicians. It is a document that says, it's got two purposes. It says, if I have a terminal condition or an irreversible condition, those two conditions, I either want a breathing tube and a feeding tube, or I do not want a breathing tube, I do not want a feeding tube. So that document came into being. I don't know if you're familiar with the Terry Schiavo case, but it was a woman, she lived in Florida. What happened with her is she was in a coma. I think she was in a car accident, but something caused her to be in a coma, and the doctor said she was brain dead. Her parents said she would have wanted to live that way. Her husband said, I had talked to her beforehand, she would not have wanted to live that way. And they fought for 2 years over whether or not to pull the plug or to leave her on life support. And eventually, after 2 years, the husband was able to pull the plug. But so having that advance directive or living will, same name, same document, just different names, having that document, you are the one that makes the decision. So you say, if I have a terminal condition, I either do want a feeding tube and a breathing tube, or I don't want those things. Or if I have an irreversible condition, which was Terry Schiavo, hers was irreversible, not terminal. So the husband said she would have wanted to be taken off of life support. So if she had just signed that document, he could have taken her off life support 2 years earlier than he did. I mean, obviously that's not, no one wants to think about those situations, but the last thing you probably want is to force your children or your spouse to make that decision for you. If you are capable of making it yourself, at least you can make it yourself and let your wishes be known to everyone else who's going to be ultimately responsible for effectively pulling the plug, right? Make it easier on them because you made that decision yourself instead of them having to do it. Okay.
Yeah, exactly. And then the other two documents are a revocable trust and an irrevocable trust. Those are two documents.
Yeah, so
how would you define those?
Yeah, so you in planning can do planning with just a will, or if you so choose, you can make your estate plan include a revocable trust, which is a trust that during your lifetime, everything flows to you, all of your income flows to you just like it would normally. It doesn't have creditor protection. It doesn't have any sort of spousal protection, but it puts all of your assets into one basket. So if you do become incapacitated later, you can easily shift the trustee to whomever you want to in the future. It also has all of your assets in one basket so that if you put them in there while you're still alive, you can actually avoid probate with a revocable trust. So wills, when you file them, when you die, become public record. A trust never has to become public record. And so if you ever have privacy concerns, you can use a revocable trust to put all your assets into it to make sure that no one really sees where your assets went at your death, because you didn't have to ever file that trust anywhere. And so it's a way to plan to avoid probate, if avoiding probate is something you want to do. Also for privacy concerns, anonymity type reasons, some people use a revocable trust. And then tax-wise, some people choose to do a revocable trust. It doesn't give you tax benefits at your generation, but it would at your children's generation. And then an irrevocable trust is a separate trust that you can do. It's irrevocable, which means you can't change it. So a revocable trust, you can change anytime you want to. An irrevocable trust, you actually get the assets out of your estate forever when you put something into an irrevocable trust. So like you would create an irrevocable trust for your children, and then you would start gifting the money slowly over your lifetime if you wanted to do so. That money is theirs the second it hits the irrevocable trust, so it's no longer yours. You can still be the trustee, so you can invest it for your children, but the asset becomes their asset and not your asset. So some people use irrevocable trusts to plan to funnel money down to future generations, or some people also use irrevocable trusts to plan for their parents. If their parents are getting older and maybe have some sort of disability, you can put money into a trust for your parents that's a specific kind of trust, especially if they're going to be disabled. We would put it in something called a special needs trust to kind of plan for them, get money to them that they can use for their lifetime, but that doesn't affect their Medicaid eligibility benefits. And you can use that for older people and also for children. So if you have a child that's disabled, you could also do planning with a special needs trust for your child as well. So those are kind of categories of trust that we use often to plan. Each family is different, each circumstance is different. And so depending on what you need, we kind of pull whatever trust we think would be helpful for the situation. But those are kind of the trusts that we use most often. There's a lot more trusts that we can do. It just kind of depends on the situation, but those three trusts, revocable, irrevocable, and special needs trust, we use quite often for individuals.
Okay, well, in the description section, there is a PDF download of the presentation that goes into a lot more detail. But if you can do this for us, let's kind of back up and from a basic or estate planning 101 perspective, clearly define what is a trust, because there's some people who don't have an idea as to what a trust is. How would you define that to someone from basic level?
So, I mean, a trust is basically any, a lot of different things can be trust, like a custodian account could be a trust too to some degree. So a trust is any document in which you are making somebody the trustee. So you have a settlor, which is you're creating the trust, a trustee, which is the person who's responsible for managing the assets, and a beneficiary, which is whoever you are giving the assets to. So a trust is basically any document that has those three things. You have to have a person that's getting the benefit of the gift, right? So you're putting it into a trust. Somebody's the beneficiary. Then the trustee is in charge of managing it, and the settlor is whoever's money it was that put it in the first place. So like a grandparent can create a trust where a parent is the trustee and the child is the beneficiary. So grandchild gets the money, parent is responsible for managing it, and it's ultimately grandparents' money that went down. That's an example of a trust, but trust can be done for a lot of different persons. Does that answer the question? I mean, that's kind of high level what makes something a trust, but there's 1,700 different types of trust. So it's a big category of things. I'm just trying to really narrowly define it, at its base level.
Exactly. And so there's all these different ways of defining it, but an individual can own an account. And outside of a actual person owning an account, you have what's called non-person ownership. And so a trust, like you said, is a document that identifies different players, but it's actually a separate entity. It's like forming a company or some other entity that's owning something. And then you identify the players, as you talked about, the trustee, the beneficiary, the settlor, the grantor. And this is why it's very important to talk to an attorney, because once you are very clear on your goals and what you want to accomplish, you now need to know what are the legal documents that are required to facilitate your goals. So since we're talking about goals, what are some possible goals of an estate plan?
I mean, controlling your assets is a huge one, right? So being able to say who gets what you want to give, right, is a huge goal that some people have. So you can preserve your assets in the event you become incapacitated. That's another goal that some people have, right? Like we talked about, if you get that dementia diagnosis and things like that. And then really just being able to be the gatekeeper of saying, it's my money, right? I worked hard for it and I want to choose where it goes. I want to choose who it goes to, how it goes to them, when it goes to them. By doing an estate plan, you can do all of those things. And then just protecting yourself from any potential incapacity by saying, without having to have a guardianship, these are the people that can make decisions for me. So those are kind of high level goals, I would say, of having an estate plan.
And then when you talk about, yeah, go ahead.
Oh, no, I was going to say, some people choose to put in special criteria, like if you want to give some things to a grandchild, but you want to give it to them to make sure they use it for college, we can put all of that into your will or your trust as well. So like planning for education is one thing that some people like to do. Also, like if you have a family business and you want to protect the lineage of who it goes to, we can do all of that with your estate planning as well. Obviously, if your estate is taxable, which right now the estate tax threshold is over $11 million, so a lot less estates are taxable. That is scheduled to sunset in 2026 currently, so it will go back down to 5 million. Still, a whole lot of states are not taxable, but if you are lucky enough to have over $11 million or over $5 million, certainly estate planning is hugely helpful to try to minimize your tax burden at your death. It is extremely helpful in that circumstance. And then we can use estate planning for some sort of creditor protection sometimes. Creditor protection isn't always possible, especially if you already are in the middle of a lawsuit. It's fraud to transfer assets out of your estate in the event that you are potentially being sued. So you can't really plan for that once something bad has happened. But prior to anything bad happening, prior to you being sued, you can certainly plan effectively to try to prevent unknown creditors from being able to take your estate.
Yeah. And so you talked about what is probatable and what's a probate asset and what's not a probate asset. And it's very important to know that if you have any accounts that you can assign beneficiaries to, you have the option of transferring that title upon your passing with it not being part of your probate. But if you haven't assigned a beneficiary, or if you have intentionally identified the beneficiary to be your estate, then those assets will go through the probate process, along with possibly your home or your car or any other personal property. So if people have a number of homes or land in different states, it may make sense to create some type of separate entity to hold those assets to avoid probate. But if they are all part of your assets and they're in different states, potentially you will have to go through a probate process in every state that you own property. Is that correct?
That's right. It's called ancillary probate, yes. So you would start with your home state. The first one you would do would be your home state. So for clients who would come to me, it would be Texas, right? Because I'm a Texas attorney. So we would probate in Texas first. And then let's say you had property in Oklahoma and Arkansas. We would have to go through a second probate in Oklahoma called an ancillary probate. It's a reduced, you don't have to do as much for it, but it's still not cheap. However, if we had just put your assets into an LLC or into a trust prior to you dying, we could have avoided that second probate altogether.
Yeah, which is another reason why it's so important to sit down with an attorney to at least put some structured thought to what do you want to have happen with your stuff after your passing.
Yes.
And let's say if you're young, you may not have a lot. So it's good to have those conversations now. But then if you look at your planning, if you want to have a home in multiple states, so if you want to have a lot of assets, if you own a business, it's very important to think about at some point, what do you want to have happen? How do you want those assets to be transferred? And can you transfer them in a very efficient, smooth way with avoiding legal cost or a court process through other documents or strategies by sitting down with an attorney or and just being prepared. So is there anything that we haven't talked about that you found in sitting down with clients that's important for them to know from a basic estate planning 101 perspective? Yes.
So one thing that I do not let anyone leave my office without telling them is you should avoid outright gifts to minors. Just if you don't hear anything else I've said, hear this, because basically a perfect example, and this happens all the time, two people get divorced and then you change your IRA or 401k from being your ex-spouse to being your children, but your children are 2 and 4. If you do that and the bank that you went through doesn't have what's called a custodian account, and then you die, what happens is the court will take all of that money and lock it up until the child turns 18. And then on their 18th birthday, they will give them all of it. So like if you have an IRA with $100,000 in it, it will get locked up until their 18th birthday. And then that child will get the entire $100,000 on their 18th birthday. So while I said naming beneficiaries is important, kind of that's where we go back to why working with an attorney is helpful. You should never name a minor, because most parents would never want their 18-year-old child getting their entire estate the day they turn 18, right? So that's where having these trusts can become advantageous, because then you can say, instead of saying everything outright to my child, everything into the trust that we created for my child. So a lot of banks now have seen this as a problem and have started to do custodian accounts. And so if they have something called a custodian account, you can certainly name your minor through a custodian account, which will let you name a trustee for that child. So if that's possible, do that. But if it doesn't have a way for you to name a custodian or a responsible party for the money, just don't name your minor beneficiary, because they won't be able to take it until they're 18. And that's when you should, especially if you're divorced and you don't want it to go to any sort of ex-spouse, you should definitely consider going to an attorney to make sure that they can effectively get the transfers to your children while they're minors in a vehicle that works for your children and doesn't lock the money until their 18th birthday.
Okay, so another thing that I've seen people do, which I don't recommend, but I want to know what your opinion is on this. Let's say you're an aging a parent and you want to make sure that your kids don't have to go through a lot of hassle upon your passing to get access to your account. So you pick one child and you create a joint account with them. And by doing that, you want this account to be split amongst all of the siblings, but you've created a joint account with them. I don't recommend that, because upon your passing, those assets become the rights of survivorship. The other joint
Right.
owner of those assets, it doesn't go to all of your kids. So what do you
That's right.
tell clients who are in that situation?
So if they don't want to do planning and they want to make sure that their child can have access to their bank account, instead of adding your child as a co-owner, you can add your child as a signatory. So you can give them rights over the account, but make sure that the account and the money is still 100% your money, right? So they're not a co-owner, they're just a signatory. So they can sign checks, they can do everything that you can do, but they acknowledge that the money is still 100% your money. And then what you would do is add all of the children as a payable on death beneficiary. So if you weren't doing planning, right, and you didn't have an estate plan, that the will would come in and take that money and make it all the kids anyway through your will, you would want to name each child and not just the one child as the payable on death beneficiary. So you can still add them, but add them as a signatory, not as a co-owner. So that's what some people, I have them do in that situation. Okay.
And then to your other point, if you are putting your children as beneficiaries to life insurance policies or to your 401k, and they're minors, in that situation too, someone says, well, I'm going to give the money to my brother and my brother's going to take care of my kids. I don't recommend that as well, because
nope, me either.
You're passing, your brother or whoever the adult is has that money and they can legally do whatever they want with it. In this situation, right, you would recommend a trust, right?
Yes, 100%. That is the perfect example of when you would want to use a trust. And keep in mind too, it's all well and good for you to say, my brother would use the money for the kids, but once you give that money to your brother, if he spends it on anybody other than himself, it's considered a gift and he has to pay his own gift tax in order to use it for the kids. So you're kind of shackling him with not just the burden, but also if he's trying to do the right thing and spend the money the way that you asked him to, he's effectively reducing his estate tax exclusion just by doing so. So I definitely never recommend just naming your brother outright and saying he'll take care of the kids, because worst case scenario, he doesn't take care of the kids at all and he takes the money and run. Best case scenario, he takes care of the kids, but he's using up his estate tax exclusion amount with every transfer he makes on behalf of the children, because it's his money, it's not their money.
So if someone wants to talk to you about their specific concerns and planning, how do they get in touch with you?
Yeah, so you are welcome. I think that there's a slide with my contact information, but you're welcome to call my office at any point. I'll say the number. It's 214-361-5600. You can also send me an email. My email is Jennifer, spelled like normal, JENNIFER, .Lewis, LEWIS, at FGHWlaw.com. So that's like Frank George Henry William. It's actually Farrow-Gillespie Heath Witter, but Frank George Henry William law.com. So that's the best way to reach me, is probably email or calling the office. If you call the office, they'll run a conflict check because we're attorneys, and so that's just how it works. So there'll be gatekeepers to get to me if you call the office, but if you send me an email, it'll come straight to me.
Okay, and if someone doesn't really have a big estate, let's say they're very young, do you still think that it's beneficial to meet with an attorney? And there's normally, for the first consultation, there's a consultation fee. Is it the first meeting with an attorney is not free, is it?
No, we charge a consultation fee. If you end up doing documents with us, we put the fee towards the documents. So at our firm, it's $350 for a consultation fee. So I'll answer any questions you have at that rate. And then if you end up wanting to do documents, that money goes towards any documents that we prepare for you. That's how it works with my office.
So prior to that first meeting, that is $350, they will fill out a questionnaire before that first meeting. Is that correct?
Yeah, if you email me and say, hey, I'm interested in estate planning, I send you a standard email that I've just prepared that has that trusted person last wishes document in it. And so they can just fill out that beforehand, and then we schedule a meeting to talk through their answers and any other questions that they may have for me or any questions I have for them.
And so I feel, because I've sat through a number of meetings with you, I feel that paying, the consultation fee, which could range anywhere from, it could be anywhere from free to $350 or even more, but sitting down with an attorney to have a structured conversation about what your goals and what you would like to have happen, and get advice from an attorney to either confirm or enlighten you of what documents should be prepared, is worth the consultation fee. Have you ever had somebody, pardon me?
I said, I think so.
Yeah, right. Have you ever had somebody sit down in that meeting and truly felt that it wasn't valuable for them?
No.
Yeah, I feel the same way. I know that, now there's some people out there who just say, I don't have the money. What do you recommend for those people to get advice? Is there any way of getting some good quality advice if they truly don't have the money for a consultation with an attorney? Have you ever ran into those kind of people, and what do you recommend to them?
So if you really, there are income thresholds for DVAP. So if you're in Dallas specifically, the Dallas Volunteer Attorney Program will do estate planning documents for people who need them, who cannot afford them. I am not sure. You should be able to find on their website exactly what the income limits are, but if you really are below that threshold, you should be able to get free documents that way by going to a will clinic or just contacting Dallas Volunteer Attorney Program. That's one way to get documents for free or for a very reduced cost. Otherwise, I would say, like we talked about, those vehicles that you can use in the event that you don't really have an estate that's large enough to do estate planning, you can always consider getting those documents. But otherwise, I would say save up and talk to an attorney, assuming that you have more money than you can qualify for the Dallas Volunteer Attorney Program free documents. I would say just kind of put it in a sync fund and, wait until you save up enough to talk to an attorney, because it really is advantageous to have an attorney prepare the documents if at all possible. But if that's not the case, like I said, really look into the volunteer attorney program. You should have one in whatever city you're in as well, assuming that your income is below that level. So for us, it's Dallas Volunteer Attorney Program. But if you Google whatever your city is and free legal services, you should come up with your bar association, your local bar association will have something, and you should be able to find it there.
That's exactly what I was going to ask. The bar association should probably know. And for those people who are low to moderate income, those are great resources that are available. So at the Empower series, our goal is to really make sure that we are giving quality information, giving education, inspiration, hope, but more importantly, it's connecting people to resources that are available out there that they are not aware of that can help them move forward and achieve their goals. So if you don't have enough income, if you're truly low to moderate income, there's some volunteer organizations out there, resources. Check with the Bar Association and ask them about it if you're in different cities or different states. If you do have the money to pay the consultation fee with an attorney, definitely it's worth it. There might even be some attorneys out there that will do a free 15 or 30-minute consultation, but I just know that whatever the fee is, to sit down and get the advice so that afterwards, upon our passing, our loved ones are not devastated, dealing with emotional grief, and then trying to figure out how to navigate through this legal maze. It's just, I've seen too many situations where that occurs. So I don't know, we're kind of preaching to the choir here, but I'm an advocate of really sitting down with an estate planning attorney and getting the facts. Is there anything else that you found in your experience, though, that is important for people to know from a basic estate planning 101 perspective that we haven't covered?
No, I think we covered pretty much everything. Just plan while you can, and then you'll be set no matter what happens. That's kind of my mantra.
Yeah, and there's some other things that we didn't really get a chance to talk about that's in the PowerPoint presentation that's available in the description. So please download that document. It's a PDF form. Go through it. If there's anything that you do not understand, Jennifer's information is there. So you can definitely contact her, or you can contact the Empower Series at thrive@empowerseries.com. We can get you connected. If you're looking for some free legal advice or services, and you're finding it too much of a maze to go through the Bar Association, or your Google search didn't land you anything that's really beneficial, definitely contact us. Don't let this be the last time that we are connecting around estate planning. And even though this is the month for estate planning awareness, and actually the third week of October is Estate Planning Awareness Week, estate planning is something that you need to do on a regular basis. This might be the time where if you already have an estate plan, that you can update it or review it every year. And Jennifer, how often do you suggest people should look at their estate planning documents to review it?
Yeah, so anyone who comes for me for planning, I give them a summary piece of paper that has the high-level decisions they made on it. I recommend they pull that out once a year and look at it, make sure no one's died, no one's become incapacitated, everything's still what you want it. And then I recommend them going through the actual documents once every 5 years. So open up the pretty color-coded piece of paper once a year, and then if everything looks good, you can put it away, and then look at the actual documents once every 5 years is what I recommend.
And what if you move states? If you move from one state to another state, is your estate planning document still good? Your will, is it still good, or do you need to get it updated?
It should still be good. Most states have reciprocity with one another, but I always recommend going to an attorney in the state that you move to look over your documents and see if anything needs to be changed. So a lot of times they'll say everything's fine, but it's worth talking to an attorney about it. And especially if you're transferring from a community property state to a non-community property state or vice versa, there's just some things that you would probably want to know from an attorney. But in general, your document should still work fine.
Okay. Well, Jennifer, I think you've given us a lot of information to digest, beneficial stuff. It's really important that people just don't look at this and not take any action, though. That's just like in financial planning. This is great information. Knowledge is not powerful. It's not empowering if you don't act on it. And so when you meet with clients, is there anything that you tell them after you've met with them to help encourage them to take action and not just say, okay, thank you, I got some good information, let me think about it? What do you do to really encourage them to take action after your first initial?
You mean in actually moving forward with estate planning? Is that what you mean?
Yeah, with estate, whether it's with you or anybody else, but just because so many times as a consultative attorney or financial advisor, we give people information and sometimes they move on it and that's great, but then sometimes they get stuck and they just don't do anything. Is there anything that you found that has actually worked in helping people take action in preparing and planning through this process?
I mean, most of the times clients will actually sign a representation agreement with me. And so I end up pinging them and kind of being that voice in their ear, asking them to move forward and keep going. And most of the time that works. Every once in a while it doesn't. But I always tell people, just imagine what will happen in the event you don't plan, and how much better off everyone that you know and love will be if you do plan. So just kind of think of them, and hopefully that will get you over the either emotional or, you know, hurdle, whatever it is, to kind of make this a priority and make it happen. So just kind of, it's not that difficult. It's not that painful. And once you're done, everyone that follows after you, all of your kids, all of your spouses, in a much better position. So it's just worth getting over that pain point of actually having to plan. So I just kind of tend to put that bird in their, you know, that in their ear.
Well, the last thing I'll talk about here is I found that now that you've got all your documents done, you've done your estate planning, you've got your will, power of attorney, medical power of attorney, your living will, you have a trust, a revocable trust if that's necessary, or irrevocable trust, and you feel like, okay, everything's done. You've identified certain players. You identified an executor, you identified certain agents for your medical power of attorney, your durable power of attorney, and probably even a trustee. But these players may not be familiar with the process. And do you offer your clients who've created these documents any type of meeting to get all of the different players that they've identified up to speed on what to happen? You know, what happens after that process is done?
So if and when anyone actually starts serving as an agent and you know, like you did the medical power of attorney and then something happened to you, I've talked to clients at that point once their agents are actually needed. I've never had a client ask me to meet with them beforehand. I think a lot of people just assume they're going to be fine, right? And so they don't necessarily go through the steps to talk to their agent. I'm happy to do that. I've never actually done that, but I would certainly be happy to do that. A couple of my clients have had, they named their children, and they've had their children on that initial meeting with them. Obviously the client is the keeper of confidentiality. So if you want other people in the meeting with us, they can certainly be. And that helps a lot in educating the children, because they're kind of there in every step of the process. So I've done that before for several individuals. But otherwise, it's just basically once they're appointed and actually working, that's when I've worked with individuals to kind of explain what it is that they've taken on as their role. But I would absolutely be happy to talk to anyone about what each of these roles means. If they wanted, you know, their named agents to have a consult call or, you know, email or whatever, I would be happy to do that. That's not a bad idea.
Yeah, I recommend that to everybody, because when I deal with clients, they've come to me because they've been assigned as the executor or an agent, and they're muddling through it because they don't know what to do next. And I just feel that that's very beneficial. And it's also beneficial, like you said, to include children if you want to, or include the people who are definitely players beforehand. I know with my estate, I've actually talked to a few of my cousins that I wanted to play a role in my estate planning process. And a few of them just said, hey, Clifton, I love you, but you know, don't pick me.
Yeah.
So I do believe communication and letting them know what is expected of them in advance will be beneficial, as opposed to them just being surprised to find out what their role is without you giving them some notice. So Jennifer, again, like I said, we can talk much longer on this, but let this not be the end. Thank you again for spending your time with the Empower Series community and blessing us with your knowledge, your talent, your resources, and your availability to answer any questions after this. So thanks again.
You're so welcome. It was a pleasure.
Okay. And for everybody who's watching, I always close off with a comment to not let this be the end, but stay connected with the Empower Series. Somebody in your circle can benefit from learning more about the estate planning process, or with the other programs we have on our social media, YouTube channel, Twitter, Facebook, Instagram, LinkedIn. Stay connected with us. Until then, I want to thank Comerica Bank, AE Media Group, and you for being so beneficial and generous with the Empower Series. If it wasn't for you, we wouldn't be who we are today. So stay connected, be empowered, and inspired to thrive. Thank you.